So we do the terms of service, and then I get a little email cease and desist from Splice. Hi, top music attorney. We removed your video from YouTube. I'm sorry that seems to piss off companies to the extent that I get threats because they're not happy with what I'm saying. I fight for you guys on this channel every single day, but apparently now I have to fight to even keep this channel. So if you're new here, what I do is music business education. I'm an entertainment attorney, I'm also an independent artist, and I take all my experience collectively together to put out content to help you with your music careers and your music businesses and just everything that you want to do and what you want to accomplish for yourself. So if you've been following me for a while, you know I am a real attorney, I own a law firm, and I've been doing this for 10 years. So we're in a really important meeting today. It's like a multi-million-dollar deal, super intense, and then I'm noticing that my phone notifications are popping off. And I'm like, oh my goodness, what is happening? So I finally kind of, look just to see what crisis is going on. And one of my team members is like, oh my gosh, Krystle, Splice filed a strike on your YouTube channel. And I was nothing short of totally mortified, not just because of the strike, which as you guys who make YouTube videos know is a really bad thing and can actually result in the loss of the channel altogether, but actually I've been in active communication with Splice this week, and specifically their legal department. So I go, oh boy, if Splice had a problem, I'm so surprised that they didn't just email me like they did yesterday, or maybe just file a copyright claim on the video. No, they filed the most aggressive thing they could, which is a strike. So let me give you a little context. A few days ago, I released a review of the Splice's terms of service. I do that. I have a series where I go through the terms of service for these music businesses, and I tell you guys what these contracts say that you're being forced to sign in order to use these platforms. And I've had a lot of requests to review Splice for a long time, and I finally had a chance to get to it. So just like I always do, I go through and I just give you the four corners of the contract, what it says. I've read thousands of terms of service. And so I just let you guys know, here's some stuff that might be good, might be bad. This is just what you should know. So we do the terms of service and we release it. And then I get a cute little email that's a cease and desist from Splice. And they give me a list, right? And they go, look, we think that you are mischaracterizing some things. We think that you are causing some confusion. And so we're like demanding that you issue a new statement, a retraction, that you just do something. And I took a look at the position that they were taking because, as you know, lawyers have a tendency to take different positions on things. And I go, you know what? First of all, I love that you actually reached out to me. To the extent that I am a spokesperson of any kind for the music business community, and knowing that we had questions, we're confused about some of the language in the contract, or we don't think some things are clear, the fact that you reached out is amazing. Thank you very much. And I go, would you do me a favor? Let's jump on a phone call, right? So let's jump on a phone call because I understand what you're saying, but we need to talk about this a little bit further because just tell me what your guys' policies are, tell me what you do, and then I can give some updates to my community. And I specifically told them that I was gonna be going live. This was yesterday. Now I go, I'm going live. And so, we did this 2-3 hours right before the show. So big meeting, right? It's with the legal department, more than one person. So big meeting with the legal department for Splice. And as we went through and they kind of explained, I go, okay, so, it's so helpful for me that you are telling me this extra stuff, and now I know. And I will also share it with my community. I go, however, the issue here is that it doesn't actually say what you're saying in some of these instances in the contract. So I go, at the end of the call, I just go, look, it would be quite the win if you made an update to your terms of service for purposes of just clarifying this. Because in the call, they're all saying, it's so important to us that we're super clear. We really are all about our creators and our users. So, okay, great. If that's the case, let's do this as a team. You guys hopefully will update your terms of service to be a little more clear. And I will concurrently do a video, providing some updates and clarifications, right? And even on that call, I gave recommendations on how I, suggest, I'm like, take it or leave it. I'm like, but this is how I would reword it. Because there was a little bit of pushback. And they're like, well, we kind of don't want to do it for this reason or that reason. I go, okay, I hear ya. But here's how I would do it. And I just gave them an example. Because I'm like, actually, it's a really easy solution. So without repeating the entire video that I did yesterday, which is now taken down, and I'll show you guys all the things here shortly, I basically just went through the email that they sent me and I go, all right, so, they're taking issue with the fact that I am pointing out the non-transferability language, right? These words that they're using and showing that it's kind of inconsistent here and there. So I go, this is what I said, this is what the term said, this is what their email said, and this is what they told me today. So here's what I can at least share with you guys. That's what I did. So I just went through and I'm like, for purposes of just clarifying, this is what they told me. This is maybe why I said something a certain way. And then I went a step further because I actually went out of my way to try to just, end this on a really positive note, to be like, I was so excited that Splice took time to have a little chat and to, hopefully try to provide some clarification to their users. And one of the things that we talked about was this certified license. So if you are using samples from Splice, they provide you a certified license. And what I was told was that this certified license is like the only thing that you need. If you ever need to do something with your song which contains the sample, if you are licensing it, if you are selling it, like any instance, you're good to go. And so in my effort to create transparency and show you guys, I'm like, hey, this is where you get your license in your account. And it wasn't my account, right? This is my show producer's account. He's the music producer. So he downloaded one of these licenses, he gave it to me, and it's just, their template language with a couple of sentences in it. So fast forward to today, we get a DMCA copyright takedown notice. Let me show you what that looks like. Hi, top music attorney. We received a copyright removal request for your video. Based on applicable copyright law, we removed your video from YouTube. And what video was it? It was my live stream from the night before, which is Splice Responds, and they go tips to start new music projects. I did a Q&A, and this is a music business podcast. They go, the content used that allegedly is copyright infringement. What Splice put is not applicable. Confidential correspondence and proprietary documentation screen shared within the video. So they say the content use, not applicable. What do you mean it's not applicable? That's the entire basis of filing a copyright infringement claim. That you are alleging someone is using your copyrighted content. But then it does go on to explain. It says, well, there was a confidential, communication, correspondence, and a proprietary documentation screen shared within the video. And then you are asked to actually tell YouTube and to tell the end person receiving this, which happens to be me, what was it? So I downloaded, of course, all my content, and so I have copies of everything. So even though it's off of YouTube right now, I still have a copy of the video. So this particular, and I think it's 57 seconds. So this particular 57 seconds is showing their certified license that we had done as just kind of like a little test to show you guys and be like, where do you get your license to make sure that you can, if you run into problems with your music distributors or your record labels or whatever. So we're just showing that to educate you and help you and to explain. So in a, almost, what was it, hour and a half, 2 hour live stream, this is what they were claiming. Okay, so that's going back and as well, who claimed it, who filed this, and we know that this is Distributed Creations Incorporated, which is the company doing business as Splice. We also have the contact information for privacy purposes. I like to give courtesies. All right, they may not be given to me, but I like to give courtesies of covering people's names. So it's one of the legal people over at Splice filed this. All right, and they go, this means your video can no longer be viewed on YouTube. You received a copyright strike. You now have one copyright strike. If you get multiple copyright strikes, we'll have to terminate your channel. So let me take a quick step back and basically just walk through this as if I was the client, right? It's not actually me, I'm advising someone. I go, well, they're identifying that there may have been a confidential correspondence. So we'll say that was the email that they sent me. It was not a confidential correspondence. And in fact, as a litigation attorney, I can tell you that when we're litigating, sometimes there really are confidential communications, which we have to identify. And we go, pursuant to Rule 408 of the Federal Rules of Evidence, this is not something that you can use if there's a lawsuit. Doesn't mean you can't share it. It just means that you can't use it in a lawsuit to prove liability. But that's not what this was. They sent me a little email saying, hey, we think that you need to clarify some stuff. So, all right, is this copyright infringement? No. They're saying it was a confidential correspondence. The other piece that we just saw is that it said that this was a proprietary document. So I'm assuming that they're talking about the certified license. All right. So if they go, this is our proprietary document and we didn't want to show everybody. Well, a big part of the conversation that I had with Splice is I go, look, my big problem here is that I sell music catalog all the time. We sold $9 million of music catalog last year. And I can tell you that when I'm looking at your terms, there's going to be problems because it's not clear. And especially in the language where it's like, you cannot assign this agreement or any of your rights here too, it at best conflicts with the other language, which is like, yeah, please go license, no big deal, you can remix, you can adapt, and I go, that's inconsistent. So I'm like asking for just clarification or updates. You need to make some updates. But back to the discussion, which was, oh, Krystle, when it comes to this, this license, this is the thing that everyone uses, right? The big labels use it, and this is the thing that freely transfers the rights. Our artists, and users, they can license, they can sell. We have no problem with any of that. I was like, wow, that's really good to know. And then I told my audience yesterday. But going back to, is me showing their license copyright infringement? The answer is no, and I'm going to tell you why. So if I was advising myself, I would go, gosh, it seems like someone has filed a false copyright infringement claim on your video, Krystle. And I would argue this is only not confidential information. It's also not proprietary information because according to Splice's own legal department, everyone can just freely give this license to whoever they want anytime, meaning other people get to see this document. This is not like a private document. But most importantly, it's not copyright infringement. So what do we do? I'm glad you asked. So what we're going to do for a second is pretend that the information that was contained in the letter, in the license agreement, the certified license, is copyrighted material. Because under copyright, in order to have copyright protection, you just need to take your creative expression and fix it into a tangible medium and have your own originality in it. So in this case, where it's like a half a page license agreement, and then also an email that was kind of rude, PS. But nonetheless, the drafter may have a claim that they have copyright protection in those things. Now again, what was actually claimed on the video is solely the license agreement in the time code that was provided to YouTube. But this is how we work through it as lawyers. So we take a peek at Lenz versus Universal Music Corporation, 801F3D 1126. And this was in the United States Court of Appeals, 9th Circuit. I am in the 9th Circuit, so this is a very applicable case. So here's a quick summary. So Stephanie Lenz, she filed a lawsuit. And this was under 17 U.S.C. section 512F. We've talked about this on the channel, actually, which is part of the Digital Millennium Copyright Act, the DMCA. And so this complaint was filed against Universal Music Corp, okay? And she was alleging that Universal filed a takedown notification of her YouTube video and was claiming copyright infringement for use of a portion of the video that contained a Prince song in the background, okay? And so she goes, well, and then, we'll get to more of the meat of the claim. But the claim boils down to a question of whether copyright holders have been abusing the extrajudicial takedown procedure provided for in the DMCA by declining to first evaluate whether the content qualifies as fair use. And in this court, they said, we hold that the statute requires copyright holders to consider fair use before sending a takedown notification, and that failure to do so raises a triable issue as to whether the copyright holder formed a subjective, good faith belief that the use was not authorized by law. All right, so quick recap. So they're saying that under 512F, if you try this little like Trojan horse thing, where really you're filing a false copyright claim, and you're going, I actually want to take this down because I don't want you to see something that's in this video. Unfortunately, that happens all the time, right? Like I said, doing this a long time. And, we have to deal with people who file false claims. And we assert the 512F, and I'll tell you why that matters. But we just go, look, you don't get to file a copyright infringement claim because you're unhappy. This is usually what it is. Because you're unhappy with what the person's actually saying in the video about you. You might have other claims, you might be able to sue, you might be able to do all kinds of things, but you don't get to use the Digital Millennium Copyright Act and what's set up through YouTube to get a video taken down. And purportedly, according to the claim itself, it was because the email and the license agreement was showed on the screen. All right, so in the court's analysis, back to this. Johnson, and P.S., Johnson was working for Universal. So he's the one that's assigned to go and find all the songs with Prince music in it and to file takedowns on YouTube. So when Universal, we'll say, had to file the takedowns, the notice has to include a good faith belief statement as required under copyright law, 17 U.S.C. Section 512C3AV, which says, we have a good faith belief that the above described activity is not authorized by the copyright owner, its agent, or the law. So, as it relates to my video and the good faith statement that was made by an experienced music attorney who works for a music business, I don't even say attorney, a team of attorneys who work for a music business who are aware of fair use, which we're going to talk about for a sec, here momentarily, said yes, we have a good faith belief that the above activity is copyright infringement. So let's keep going. All right, so Lenz, right, filed the second amended complaint and alleging, because there were other claims and they eventually got dismissed. So, but alleging, we're back to the 512F, okay? So that there was a claim for misrepresentation under 512F. Well, you know what? What does 512F say? The court goes on to discuss if an entity abuses the DMCA, because this is something that is set up to help people to protect their copyright, that the entity doing this thing may be subject to liability under 512F. The section provides, quote, any person who knowingly, materially misrepresents, right? You file a fake claim under this section that material or activity is infringing, so you're making a claim that the stuff in the video is copyright infringement, shall be liable for any damages. And I've read the statute so many times, I can just tell you what the rest of that sentence says, which is any damages incurred by the alleged infringer, whether they're actual damages or their attorney's fees. So, as a law office, we make this argument all the time. And we go, usually we're just trying to sort this out. And we're like, just please retract, your claim. And sometimes it's made because people just make a mistake. They don't understand. And we go, just so you know, it does say this. We are able to come after you for like damages and attorney's fees and all this stuff happening. So before that happens, and before this escalates, please just retract your claim. Fair use is not just excused by the law. It is wholly authorized by the law. In 1976, Congress codified the application of a 4-step test for determining the fair use of copyrighted works. And this is what it says. Notwithstanding the provisions of sections 106, 106A, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors shall be considered include, and this is how the court looks at this. And guys, just for context, because sometimes people will hire our office to provide a fair use analysis because maybe someone is doing a documentary and so they're using pictures and video clips that are copyrighted and belong to other people. But their documentary may qualify as fair use, and if it qualifies as fair use under the law, you are okay to include it in your, let's say, video. But there's 4 factors, okay? And the courts generally look at these. They don't take all of them. Sometimes they'll weigh different things a little heavier than others, but this is what the factors are. So they go the purpose and character of the use, including whether such use is for a commercial nature or is it for a nonprofit educational purpose, right? Are we just trying to educate people, okay? 2, the nature of the copyrighted work. What is it, right? Is it something where you have invested, I don't know, hundreds of thousands of dollars, you've made a feature film? Is it an email that took 30 seconds there may be copyright in it. But the court looks at this as far as what is the copyright thing that you are upset about. Number 3, the court looks at the amount and the substantiality of the portion used in relation to the copyrighted work as a whole, right? So, for example, how much did we actually need to use? If I'm like, hey, I'm doing a documentary, and then, I go, this is a documentary talking about the different types of films in the world, and then I literally just have the whole, all these films just play from start to finish. That doesn't make sense. If I'm using a representative portion, like a little portion, I'm like, hey, so this is like a horror film. Oh, this is like a, and so I go through for purposes of making my educational point. That would weigh towards fair use. And then number 4, we have and consider the effect of the use upon the potential market for or value of the copyrighted work. So we look at basically what's the impact on the market? Is you using this copyrighted thing damaging the original thing, right? And sometimes the answer is unequivocally yes. So is me talking about this certified license in a very positive light, which I did. I go, hey, here's the thing. This is what they said. Use it. This is the, everyone, it's accepted in the industry. And so me just showing you what it is so you know where to get it and what it is this damaging splice in the market or devaluing their certified license? In my opinion, no, it's not. And again, even as it relates to the email, and they're like, hey, you didn't make us look very good because we were going to mean to you in the email and it kind of made us look not so good. Okay, that's not copyright infringement. So let's keep going. 17 USC section 107, the statute explains that the fair use of a copyrighted work is permissible because it is a non-infringing use. So I gave this a little thought and I go, all right, so, my channel has about 1,300 educational videos on it, all dedicated just to helping you guys with, understanding the music business, understanding how to stay protected legally. And I was like, let me try to figure out what it costs for me to do what I do and what I've done to date. And so I go, all right, 1,300 videos, and, we take holidays off, but otherwise I do this once a week just for the live show segment. And so, that's approximately 50 shows a year. So that's, over the course of 4 years, about 200 shows. Each show that I do is no less than 6 hours from prep to recording to, all the stuff we have to do afterwards. So basically that brings us to about 1,200 hours that I've invested to get the channel to where it is. And if we multiply that by the time that I take off of work, right, as a full-time lawyer, we're now in the multiple 6 figures. So that's the value of this channel by itself that they've now put at risk because they chose to actually file a strike against the channel. And of course, that doesn't account for other time invested by editors that, edit the videos so you guys have videos all throughout the week. Now, here's the thing. I go back to, we did the live stream, but that's the way that I do this channel is that we do the live stream and then I cut up all the different videos and segments of what I talk about. And that's what we release throughout the week. So the actual video that we have been editing and we were planning on releasing was meant for purposes, and they saw it, that's why they filed the claim, but was meant for purposes of not only providing clarification specifically from Splice, because, on our call, I just pointed out some things and they, clarified. For example, one thing that came out, it had to do with your access to your account, and then also the certified licenses that are so important that you download that it's the first time I've ever heard about it. And I represent producers all the time who use Splice. And so one thing that Splice Legal had shared with me was that they're like, you never use... Well, and in fact, to be honest, they actually conflicted. 2 of the attorneys. One said, you are good to have access to your account for 5 to 6 years. And then the other one jumped in and said, no, it's forever. And even if there is a problem, you can reach out to our copyright email and we'll help you. And so then, on that call, I was like, hey, so just so you know, when I went through your terms, it actually doesn't say that. It says once you are done, you are kicked out of your account, you no longer have access, and that's why I stress to my followers that it's just really important that you download your certified license, which proves that you are okay to use the sample in your song. So there was my reaction to this, but my show producer, who has been a part of this channel since the very beginning, he was quite up in arms and he goes, what are they trying to hide? If this really is about the certified license, what do they not want people to see that they then filed this false copyright infringement claim against your video to get it taken down. So, to be clear, I really would like to release that video, but it's gonna be really tough while I have already one strike on my channel. And the idea was literally to help you guys and to convey what they shared, but then also to provide clarification on the language in their terms of service that literally conflicts. Whether this is actually me and my channel, or if I was just advising someone, I would say this is completely and utterly outrageous, and I'm pretty disappointed in Splice. Now, I do want to say that I do not want you to hate on Splice, okay? This is my fight. It is not yours. My honest hope is that they will voluntarily retract their copyright strike on my channel. And the only ask that I have, which was in my video yesterday, is that Splice needs to update its terms of service. And in fact, their legal team told me that they would. And if you have seen my original review of their terms of service, if you think that Splice needs to update their terms to just better clarify that you have an unrestricted right to use the sound within your song, including for purposes of selling your song, so long as you don't do all the things that we go through in their terms, such as just taking their samples and reselling them as sample packs. If you think some updates would be helpful, leave your comments down below. Now, because this is an educational channel, I thought I would show you what I'm filing as my counter notification on YouTube. So a counter notification, basically, this is like the appeal, right, on YouTube. So Distributed Creations Incorporated, which is Splice, hereafter claimant, improperly issued a copyright claim in violation of the Copyright Act, which is 17 USC 101 sequential. Claimant's copyright claim lacks merit and is made in bad faith. Claimant blatantly ignores the fair use nature of the video, which is pursuant to 107, and therefore fails to uphold its burden in Lenz versus Universal Music Corporation, which we just went through. The creative YouTube video at issue, which is hereafter the YouTube video, of top music attorney, hereafter YouTuber, is an educational and transformative video providing a legal reaction to documents provided to claimant's users. The video also analyzes claimant's terms of service in particular, which are publicly posted on its website. This is not a confidential thing. Splice has it on its website. The YouTuber provides commentary and criticism and education for users utilizing claimant's website. The document in question is displayed on the screen for 57 seconds, and the YouTuber educates users on its purpose and use. This YouTube video and use unequivocally qualifies as commentary, education, and criticism. So real quick, guys, if you want to freeze frame, this video, this is language when you do file your counter notifications. If you are claiming fair use, if you were saying someone filed a claim, it's wrong because I did have the ability to, let's say, if you just cover news, you're like, I am reacting to this for commentary, criticism, so this is the language that you would use. This YouTube video constitutes non-infringing fair use under US copyright law because it is transformative in nature. It uses no more of the original than necessary to make the educational point and has no negative effect on the market for the original work. Thus, under Section 107 of the 1976 Copyright Act, the fair use factors weigh heavily in favor of good faith, fair use. Courts have already weighed on this question. YouTube videos of this nature are fair use as a matter of law. And we cite to another 2 cases. Thus, claimant's copyright claim has no merit, was not made in good faith, and must be removed immediately. The YouTuber appreciates your review and consideration. So just a pro tip, it's helpful when you are just as factual as possible when you are submitting these counter notifications, just to help it along. Because quite frankly, had we, drafted this out of just, emotion and being like, this is what they said in their claim. They're like, there's a confidential communication, there's a proprietary document that I'm seeing, and oh, by the way, as it relates to the claim of copyright, it's not applicable. So rather than just kind of getting into that and just being like, to the extent that you guys take as what they're saying is true, that it is copyright infringement. Because there may be copyright in these things, right? We go regardless. This still qualifies as fair use, and this was a very improper claim that was filed on this video. To be clear, I do not want escalation of this matter, and like I said, I really would love to release that video, even if they would like me to take out the alleged showing of the license agreement, I can take that out. It was literally meant for the users, for you guys just to see in case this is like news to you. I could certainly take that out since that seems to be the big issue here. But I did want to mention in regards to the 512F damages and the fact that they have filed a false claim for copyright infringement because pursuant to the law, as we read, they were required to consider that this could have qualified for fair use. And not only that, we don't have a layperson who filed this. We had a legal department who's very familiar with the law, and this law in particular. And I mean, the nuclear option with all of this, if I was advising myself is, eventually we can just get an injunction because maybe let's say I release that video, right? It's almost done being edited and they decide to file a second copyright strike. Well, even at this point, getting an injunction, getting a court to say you Splice are violating the law, you cannot file these DMCA copyright infringement takedown notices. And I have all of these options because I'm not only an attorney, but I'm an attorney who also has a team of attorneys that work for me across the United States. And that's not fair. That's why I do this channel, because I can go to bat for myself and I can just go as long as I need to go on this. But you guys don't have that option. And that's why I review these terms of service, because it's important that you understand what these companies are really saying and what you are required to sign to use their services. And I'm sorry that seems to piss off companies to the extent that in some instances, now I get threats, or I actually have a company take legal action against my YouTube channel because they're not happy with what I'm saying. Like I said, I do this channel because I'm just so passionate about music. I've been doing music since I was 4. I'm an independent artist. I run my own record label. And I became a lawyer because I wanted to learn how to protect myself. So I go, you know what? For the people who are like me, who want to learn how to protect themselves in this music business, I'm gonna help them. Please be sure to leave that comment below if you would like to see that Splice video. And most importantly, if you think that Splice needs to update its terms of service.